Hi, guys, and welcome back to True Crime After Dark. Sarah, your host here. We got another video about the Chris Watts case. This one is a little scary. It's autopsy report was never given to the defense side or Chris Watts at all, and some are saying that it was the Ruzak's family that didn't want it to come out, but the DA and the plaintiff in the case would be the district attorney Rourke. He did everything in his power to deny them be able to see the motion on Chris Watts' defense team. So why would they want to hide that evidence? Why would they want to hide the autopsy results? So let's get into this video. Before we do, leave a like and please subscribe if you're not already. That helps me out so much. Let's get into this video because I've got a lot of questions.
Buried in the paperwork of the Chris Watts case is a motion that almost no one has talked about. It wasn't about guilt or innocence. It wasn't about evidence we already knew. It was about people, witnesses that the prosecution claimed hadn't been interviewed yet. And according to Chris Watts' defense, the DA was desperate to keep these witnesses a secret. Why? Well, once you hear who these witnesses may have been, you might start asking some even more uncomfortable questions.
I think we can all guess, or we pretty much already know who these witnesses are, and why weren't all the witnesses in the case questioned? I don't understand. It doesn't make any sense. It seems to me like the DA messed up so bad to where Chris is pretty much entitled to a retrial and appeal. He can appeal this because evidence was kept from his team, and that's scary. But by the way, this video is originated from Unapologetically Me, True Crime. She does have some awesome videos, so if you want to go check her channel out. But let's continue.
As if we haven't asked enough already. Hello, everyone. Welcome back to UMTC. How are you all doing today? I hope you're having a great day, week, weekend. I hope you're ready for some new information on the Watts case. Please like, share, comment, and if you really like these videos and you're learning something from them, please feel free to subscribe. It is a free way to support the channel. Thank you to all my subscribers and my members. You can always check out my community page for any updates, so I don't use up anyone's valuable time explaining things during these videos. I am just going to start going over to the community page to talk about anything that I don't want to waste time with in the videos. So let's get into this court document that is seemingly innocuous, yet is anything but, at least in my opinion. In the Chris Watts case, there was a motion filed that most people have never even heard of. One that hints there may have been witnesses who have not yet been interviewed. Who were they? And why did DA Michael Rourke fight so hard to keep them a secret? This is a copy of a motion that was filed by Chris Watts' defense team on October 19th, 2018. This motion was filed as a backup request to another motion that was filed by Chris's defense team. This motion was a backup motion in case their main motion, which was to intervene in civil case number 18 CV 30907, was denied. This civil case was to publicize the autopsy reports. In simple terms, Chris Watts' defense was fighting to make the autopsy reports public. If the courts denied that request, they wanted a hearing held, a public one, where the DA would have to explain their reasoning for keeping those autopsy reports sealed.
Isn't it like the constitutional right to both teams, the defense and the state, have to have all evidence shown to both sides? I mean, isn't that like against the law to not share evidence with the defense team? I mean, I know there was a plea agreement, so that might change things, but To me, that seems like the DA messed up big time and they were trying to hide something.
Many people still believe to this day that Chris Watts was the one who had these autopsy reports sealed. The fact is, he did no such thing. The fact is, his defense team tried to fight this and filed a few motions specifically about the autopsies, and this video is about one of those motions. There has also been opposing speculation that it was the Rusiks that filed for the autopsies to be sealed. This comes from those who believe that they are hiding something, they being the Rusiks. But it was the DA who wanted those reports sealed, likely, in my opinion, under the guise that he was protecting the victims and their families. Yet, Chris Watts and his defense team were never allowed to see those reports either. That is against the constitutional rights of the defendant, Chris Watts.
Exactly.
So why all the secrecy? There are obvious reasons that the prosecution might have resisted releasing the autopsy reports. The first reason would be protecting the victim's privacy and dignity. I mean, we all know autopsy reports contain graphic medical details about the victims, often including photos and diagrams. Prosecutors can argue that releasing these details to the public could be unnecessarily traumatic to the victims' families, especially in a high-profile case where the media will report every single line.
Or the DA might not have wanted the autopsy to come out because that would show that there was more people involved. And he just wanted to go after Chris Watts because we all know that the DA was protecting Nichol Kessinger because of her daddy working for the Colorado Bureau of Investigation. So that would make sense to me. It also seems like he had a lot more reason than just not getting the death penalty to take a plea agreement. I mean, if it was me and I had done these heinous crimes, I would have taken the case to trial. But in his case, he took a plea agreement, and it seems like there was more to that, like maybe protecting Nichol Kessinger. Let's continue.
In this case, Shanann was also pregnant, and the children were very young. It goes without saying that the contents would be extremely sensitive. The second reason would be to prevent public misinterpretation. I smirk when I say this because it happens all the time. Every single case, every single thing that comes out of a person's mouth these days can be misinterpreted. You certainly don't want autopsy findings being misinterpreted. Autopsy findings can be very technical and they're easily misunderstood without medical expertise. In cases with huge media coverage, small details can be taken out of context, fueling speculation or conspiracies. Prosecutors might worry that this could make it harder to find unbiased jurors during an active case or cause public backlash. The third reason would be preserving the integrity of the case and investigation. Even though Chris Watts pleaded guilty very quickly, there was still a period before sentencing when evidence management mattered. Prosecutors sometimes keep autopsies sealed until after all proceedings, including sentencing and appeals, are complete, to avoid influencing potential witnesses or affecting ongoing investigations. For example, if they were still looking into whether or not anyone else was involved. And the fourth reason being complying with the state law. Now, in Colorado, autopsy reports are generally public record, unless the court seals them for a specific reason, such as privacy or interference with an active investigation.
But the defense team has every right to see that evidence in the autopsy report and anything to do with the case. Unless something to do with the plea agreement and it not going to trial, if there's a law that stops that, then it looks like that he might be eligible to do an appeal and get it and have a retrial, because it looks like they really messed up this case.
The DA wanted these sealed. They would have to show good cause. And that is what Chris Watts' defense team were challenging in this motion. Why would Chris's defense team have to fight and force the court to hold a hearing on why the DA claimed that releasing the autopsy reports could taint witnesses? Because that is the reason the defense was given for the lack of transparency in regards to these autopsy reports.
What witnesses? There was no trial. I don't understand. Can you guys explain it to me? If you can explain any of this to me, please let me know down below. I'm not a lawyer. I don't pretend to be at all. So this is really confusing to me how they did not get all the evidence for both sides.
Not to protect the victims or the families, but because the information listed within the reports, quote, could result in tainting witnesses who have yet to be interviewed, unquote. It was also stated that the other reason for not releasing the reports was, quote, that the results of the autopsies will taint potential jurors, unquote. Chris Watts' defense argued that claim to be, quote, groundless because the results would assuredly be revealed within the court well in advance of a trial, unquote. So let's break that down. Let's unpack that. What the DA was basically saying is that if the public, including witnesses or potential jurors, sees the detailed autopsy findings before trial, it could influence what they remember, how they interpret the case, or even what they claim to know. Specifically, the DA's reasoning was to prevent witness contamination and jury bias. Now, this is extremely interesting in the Watts case, unusual even, because Chris Watts was arrested August 15th and he signed a plea deal November 6th. The DA's stated concern, quote unquote, potential jurors, usually applies when you expect a full jury trial.
So Chris Watts, 4 months into this investigation, already accepted a plea deal. That shows me that there's more to why he accepted this plea deal. Probably to protect Nichol Kessinger and not have her involved, because it makes no sense before any investigation is complete to take a plea deal. Doesn't make sense to me.
In this case, there would be no trial. That would seem that either they didn't know there would be no trial when they filed this civil request to keep the autopsies private, or they still wanted to limit public access for reasons beyond jury concerns, such as protecting the families and avoiding public speculation, though that was never stated as a concern in the civil document that was filed. So, what does this motion reveal? The DA's public reason, according to court documents, is that releasing the autopsy reports could bias potential jurors and taint witness statements. So the defense had a rebuttal, and that rebuttal was, juror bias is a weak argument. Autopsy details are going to come out in court anyway. The real issue was the DA's claim about witnesses who hadn't yet been interviewed, suggesting the prosecution knew about people whose stories could change after seeing the coroner's findings. They suspected the DA had information they were not sharing with the defense. Why is this important? Well, first of all, it's illegal.
Exactly. It is very illegal. And does this give Chris Watts an opportunity to get a retrial? I don't know. I know that I really hope that this case does get relooked at, and I hope Nichol Kessinger gets reinvestigated, but I don't understand why the DA did not do their job. Why did they not investigate everyone? Why did they not investigate the friends, question the friends, the MMA fighter friend she had? Why? It just makes no sense. Make it make sense to me, guys. Please tell me in the comments what you think about this.
It's against Chris's constitutional rights to not even be shown the autopsy report and to not know information that the prosecution has against him. If the DA had information they were not sharing with the defense, this means that there were people out there with potential critical knowledge about the murders, and or the DA didn't want the defense team exposed to certain evidence yet, or at least didn't want their existence widely known. Another thing this motion reveals is the coroner's role in keeping the autopsies sealed. You mean all this time there was another person who was cool with hiding evidence? Not just DA Michael Rourke, but the coroner for Weld County as well? I can't remember his name, but I will put it in here as an edit. Now, we learned this from this document. We learned it from the following statements contained within this motion. According to the petition filed, that 18 CV 30907 motion filed just prior to this one, the coroner whose office is ostensibly independent from the DA's office, quote, concurs with the DA's reasoning, unquote, and has, quote, no reason to doubt the DA, unquote. It goes on to say, and try not to laugh because none of this is funny, but they put these little digs into these court documents. And DA Rourke put one into the autopsy file, and it's almost like here's a rebuttal from Chris's defense. But it says, quote, counsel of Chris Watts cannot share the coroner's apparent confidence. The coroner's naked deference to the government has therefore made clear that he has no interest in challenging the government's judgment. Consequently, he has no interest in investigating and ferreting out the validity of its claim. Mr. Watts does. Now it goes on to say, the respondents to the action may have some interest in determining the validity of the government's witness claim, but their interest can, of course, be no greater than that of Mr. Watts. Mr. Watts is constitutionally entitled to know and meaningfully challenge the evidence and witnesses against him, and to have and make use of any and all information related to their veracity or credibility. Because of the government's claim that the release of the autopsies may taint witnesses who have...
What witnesses? What witnesses are they talking about? Nichol Kessinger. I mean, they did talk to her. They didn't interrogate her like they should have. They did not. And there was a couple other, like her friend, the MMA fighter friend from high school, and the other friend, the one whose truck was seen in the area that morning. There's just they messed up this case so bad, and let's hope it does not come back in Chris's favor at all.
Have not been interviewed seems to suggest that there are witnesses that the government knows who may slant or change their testimony based on the autopsy results. Mr. Watts has an obvious and substantial interest in developing the record on that claim. In addition, because that result, if true, has a direct effect on the criminal proceedings in this case, this court, should the court deny Mr. Watts' request to intervene, must hold a hearing in this case. So basically, if the judge denies the defense the opportunity to have this information, then there needs to be a hearing, a public hearing, where the DA has to explain why. Why are we not sharing this information with you? Why are we doing this? Now, here's where it gets even more interesting. Even more concerning, though, the coroner requested the court allow him to offer specifics about his agreement with the DA, quote, under sealed to the court in a closed hearing, unquote. Now, what this means is the coroner's office sided with the DA and even offered to explain their agreement behind closed doors, meaning Chris Watts and his defense would never even know what was said. If the court were to allow this extraordinary request, Mr. Watts would be denied the opportunity not only to challenge the evidence, but also, and obviously more egregiously, to even know what the evidence is. Now, this is the defense arguing that this secrecy violated Chris Watts' right to a fair trial.
Which makes it illegal, which makes it appealable, which makes him eligible for a trial. I was going to say retrial, but he didn't get a retrial. He took a plea agreement. I'm not sure if there's a law in Colorado or not. There's some states that have that law, but I don't know if that changes the facts because he took the plea agreement, if he can't appeal or what. If you guys know, let me know in the comments.
Oh, the irony and hypocrisy. I mean, it just can't be made up. And this is where I get into it in the comments with some people. Here in the US of A, all individuals are entitled to due process. Withholding evidence and failing to prove a person guilty beyond a reasonable doubt in this country is illegal. Whether or not a person comes forward and claims to have committed a crime, it is still the prosecution's burden to prove it.
This would have led to a mistrial if he had gone to trial. I mean, they messed up this case so bad, and it just makes me think it's because of Cole Kessinger's father. It's just, that's the only thing I can keep thinking about when I hear all this stuff that they messed up in this case.
Someone to sign a plea bargain waives that right of the accused. And I've been wanting to talk about this on its own, but there was never even a preliminary hearing on this case. You may also know it as a probable cause hearing. This is where the state has to list off all the evidence that shows cause as to why they are confident in charging someone with a crime.
Once I know what the official charges are that are filed by the district attorney's office, I'll inform you of the nature of the charges. If charges are filed, you have the right to a jury trial, and you have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that you committed any of the charges that are filed by the district attorney's office. Do you understand that? Yes, sir. You also have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offenses charged were committed by you. Do you understand?
Chris Watts never had one of these. This usually happens pretty quickly, yet there were other motions filed by Chris Watts' defense, and one of those stated that as of August 29th, 2 weeks after Chris Watts was charged with the murders, he had still not received a single page of discovery. Yet the court unsealed the affidavit on August 21st, and the media was already reporting on it, stating that the information was coming directly from sources close to the case and law enforcement.
That should be illegal too. I think it is. I mean, the discovery should have been available to his defense team immediately, and I'm not sticking up for Chris Watts at all. He is where he belongs, or worse. But I'm just so afraid that all these mess ups in the case is going to benefit him in some way. I pray that doesn't happen. Nichol Kessinger, on the other hand, needs to be reinvestigated. When we get a new, capable DA in Colorado, that's going to happen. Mark my words, it will happen.
Now let's bring it back. Let's reel it back in here and bring it back to the motion at hand. The witnesses that have not yet been interviewed, that may or may not be tainted by the evidence contained in these autopsy reports. Who could these witnesses be? In theory, of course, because this can only be speculation, this first theory is my opinion, which is backed by connections that I have recently uncovered and shown to you in part 3, episodes 1 and 2. This would be Nichol Kessinger's inner circle, her friends, family, co-workers, and certain contacts in her phone records who were not interviewed yet and never would be. We also have to think about neighbors on Saratoga Trail, people who saw vehicles or suspicious activity, but they didn't speak on record immediately or formally. Connections to the mysterious older model gray Ford truck with a camper shell, matching a Ford Ranger owned by a William Biscay at the time of the crimes. Nichol Kessinger had phone calls with this man, whom she used to work for years prior. She had conversations with him before and after the crimes. And of course, I cannot leave out,
that was the truck that the neighbor had reported seeing in the area and driving down around Chris's house the morning of the murders.
the Russian concussion, Gino Shvedov, Mr. Rear Naked Chokehold himself. Now this is a connection that potentially leads back to high school. Both Nikki and Gino were the same age, they went to the same high school, they grew up on the same street, and they also both used their home addresses on that same street to start businesses.
This is the guy that I think may have, if there was another person in the house besides Nichol Kessinger that morning, that it may have been this guy right here.
Gino, a sober living home, and Nichol Kessinger, a yoga studio, which she dissolved shortly after the murders. We haven't gotten into that just yet though, but we will. Now Gino was out on parole at the time of these murders, and he is the self-proclaimed owner of Hazelbrook Sober Living and a non-profit organization called Paradigm One in Aurora, Colorado. Paradigm One is the recipient of government funding from Denver's cashforcaring.org. Because of his sober living transitional homes, Gino has deep links to the Department of Corrections and parole officers, as well as access to communities where information can spread quickly and where witnesses could emerge unexpectedly. And last but not least, there could be uninterviewed first responders who hadn't given formal statements yet, or civil case participants as potential witnesses. People attached to the public records battle over these autopsy reports who might overlap with the criminal case against Chris Watts as well. Now, allow me to ask the big question. If these witnesses had information that could affect this case, why weren't they interviewed right away? Was the DA protecting the trial, the victims, the families? Or was he protecting the narrative? His narrative. What was DA Michael Rourke?
I think it's a little bit of all three, because I think they were trying to protect witnesses like Nichol Kessinger, and I think they were trying to protect the whole narrative, and I would think they were also trying to protect the Ruzak family, because that was horrible. It was a horrible thing to go through, and if they would have had to sit through trial, that would have been horrible as well. But if they had a trial, then I think the case would have turned out a lot differently. And I think Nichol Kessinger would be sitting along beside him in jail. Not beside him, but in the women's detention center.
Trying so desperately to hide. He wanted Chris Watts for all 4 of these murders. What could the autopsies possibly show that would make his narrative fall apart? One would think that the autopsies would prove, or at the very least not disprove, that all the evidence pointed to Chris Watts committing these crimes. So why keep them, even from the defense team and Chris Watts himself?
Because it probably showed something that would prove that someone else had to have been involved in like the little bruise that Shanann had on her neck. If she was strangled by Chris and enraged, like he says, then she would have had the broken bones in her neck. She would have had a lot of bruising on her neck. It just doesn't make sense. Make it make sense.
I'm asking you.
Let's continue, though.
I know what I think. I have my opinions. I'm asking you. What do you think? My opinion? Chris Watts' attorneys were pushing back hard on the DA's secrecy. They were suggesting there might be undisclosed witnesses or information that could help the defense, and that the DA was using the quote-unquote witness tainting excuse to keep it hidden. They are subtly hinting that there could be more to the case than what is public, or at least there are more people with information relevant to the case that had not been interviewed yet. Chris Watts and his team were basically denied information and evidence, leaving them unable to challenge any of it. And worse still, they were denied even the knowledge of what any of the information or evidence was. Now, no matter what, Christopher Watts had constitutional rights to 1, know the evidence against him, 2, test the credibility of witnesses, and 3, to get a fair proceeding, which is the right to a fair trial. Without these 3 things, Christopher Watts' rights would be violated. This filing wasn't just about autopsy reports. Chris Watts' attorneys were using the fight over disclosure to probe whether there were witnesses of information they hadn't been given, which could in turn open the doors to other evidence or even weaken the prosecution's case. They were also making a constitutional argument by saying, you can't secretly give evidence to a judge and keep it from the defense if that evidence could affect the outcome of the case. And that was with regard to the coroner and DA having that private little hearing with the judge about why they really wanted to seal.
If this case would have went to trial, it would have been a mistrial with this happened. This is crazy ridiculous. They totally messed this case up. And they were trying to protect someone. And we all know who that someone is. If you've been following my channel, you know that I want that someone to be reinvestigated. But let's continue.
The autopsies. It all sounds a little shady if you ask me. The lies we have been told by the DA are not forgotten. He has deliberately misled the public on multiple occasions, and in my opinion, he personally hampered the CBI and FBI's investigation into this case.
Because Nicole's daddy was CBI. That's why. That's why she was protected. That's why she wasn't grilled. And that's why she's not behind bars.
It's a disgrace to the people in the state of Colorado to know that if a violent crime takes place in Weld County, the DA will not pursue justice. He will pursue a plea deal before ever even looking into any evidence, in my opinion, allegedly, and no one, it seems, will challenge his opinion. Because if this motion filed by Chris Watts' defense team on October 19th, 2018 was granted, and there was a public hearing where the DA was forced to publicly disclose why he really wanted those autopsy records sealed and name those, quote, not yet interviewed witnesses, unquote, we might have a very different understanding of what happened in Frederick, Colorado on August 13th, 2018.